Hi and welcome. Welcome back to my channel. Today we'll look at what charges are in criminal procedure and the rules that govern how to write an effective charge sheet, what is accepted as a proper charge sheet, and what things or which things that you should avoid. All right, when drafting a charge sheet. All right, so generally when somebody is arrested, they have to be arraigned before a magistrate or a judge, okay, in within 24 hours. And when that happens, the police would have already drawn up a charge, okay, showing the offenses that the person is being called to answer for, okay, or has been arrested for. Now, in Kenya, a charge sheet is normally drafted with these columns and rows, and it has the OB number indicating the date and the number of complaints on that specific day of the month and year, okay, that complaint was made. The police normally draft charge sheets, and they will include a police case number, for example, number 145 stroke 4 of 2018, date to court. They'll indicate the date that the person is supposed to be arraigned in court, and the court file number. Then we have this box where we have the first column being the names of the person in full. For example, we take it like Frederick Mangeni as an example, the name of the person who's being charged. Their surname is the next column, that is Odinga, and we have the next column after that being the identity certificate number. Is this really identity or ID number? I don't know why they wrote identity certificate. Okay. So then we have a column for sex, whether he's male or female, the nationality, whether he is Kenyan or a foreign national. We also have the apparent age of the person, and address, including the district and location where it is ascertainable. For example, in this case, we'll take Nairobi County. Now, a charge sheet is followed by after what we have pointed out, being in the preliminary columns, and identification, name, and the sex and the age. The first thing that is followed is the charge that the person is being charged with. So, for example, an example of a charge in this case would be stealing contrary to section 268(1) as read with section 275 of the Penal Code. Now, under the rules of Criminal Procedure Code, where the person is being charged, you must quote the section that is provides for that offense. So if it is stealing, you don't just say stealing, you say stealing contrary to section so and so of the statute or the code that is giving that offense, okay, or is making that an offense. The next thing after indicating the charge is particulars of offense. That is a rule under the Criminal Procedure Code, section 137. It says that the charge sheet should contain particulars of the offense, and you try as much as possible to avoid any unnecessary technical terms, as well as include the the details, the relevant details, including the date that such an offense has been committed, the time, the place, what was stolen. In this case, when it is stealing, what was stolen, okay, what is the value of that item that was stolen. So in this case, we have particulars of offense, Frederick Mangeni Odinga, colon, on the second day of January 2018 at around 22:30 hours at Upper Hill, China State Construction Engineering Corporation within Nairobi County, stole 3 pieces of galvanized iron sheets, all valued at Kenya shillings 1,809. The property of China State Construction Engineering Corporation Limited. So we see here that the particulars are also stating the name in bold and it is underlined. So you start with the name in bold and it's underlined. Frederick Mangeni Odinga, underlined in bold and caps lock, that is in capital letters. Then you put a colon. Then you start saying where which time, which day, which month, which year the offense was committed, where, what was stolen, and you write the number of both in figures. If it is 3, you write 3 in figures, in brackets, and in words 3. The word 3 pieces of which value is this one. You indicate the value being property of this corporation. Then the next thing that comes is a column that indicates whether the accused was arrested. So it reads, if accused arrested, then followed by date of arrest, then without or with warrant, and then date, apprehension and report to court. So the date of being arraigned in court, the bond or bail and the amount, or whether he is in custody, then followed by is application made for summons to issue. So the answer here, an example, if accused arrested, the answer is yes, it falls down beneath that column. Date of arrest is the 2nd January, the 2nd day of January 2018. So the day of arrest is the day of the offense, that the date that the offense was committed. So he was arrested on the same day. With or without warrant is without warrant. I think this is like a cognizable offense, stealing. Then date of apprehension to court was on the 4th, all right, of January. Bond or bail and amount, the answer is in custody. So he wasn't released on bail. He was in custody, remanded in custody. Is application made for summons? That was not fair. So remanded or adjourned, that is the next column, which did not have anything. Complainant and address followed that one. Handsome, Corporation, China State Construction Engineering Corporation Limited. All right, so the witnesses is the next column. So the witness, number 1, Handsome, number 2, Ibrahim, number 3, Alio, number 4, Musango, and number 5, others to be stated. So for example, if you are still as the police, the investigative officer, you are still expecting there to be more witnesses, but you don't know them for now. You just simply say others to be stated. Now, then that is followed by sentence, court, and date. So we have a sentence for court and date. That one is, I think you just simply say whether there was any fine paid, maybe for stealing. Yeah, so, and that is signed by the officer in charge of the police station and stamped by the seal of the officer in charge. Also, it is signed and sealed by the office of the director of public prosecutions. All right, so that is one example of a charge sheet. Another example is given here as well. So we have the Kenya Police charge sheet, that is the title, police case number 122/485 of 2012, date to court 14th of August 2012, court file number, some numbers there, and OB number 16 13 8 16/13 of August 2012. So the full names: Vincent Wambua, surname Musia, ID number, they didn't have it, so it's nil, sex male, nationality of the person or the tribe. I don't know why they would write the tribe. Nationality should suffice. Maybe it is to to identify them. I don't know. So here we have a nationality, and a nationality or tribe. We have Kamba. Apparent age adult. Address Nairobi. Then that is followed by a charge. The charge is defilement contrary to section 8 subsection 1 as read with section 8 subsection 3 of the Sexual Offences Act number 3 of 2006. So we see again there is a quotation, or the statute that is making this act a crime is being quoted, exactly the section and the statute. Now that is followed by particulars of offense. That is the particulars of offense. It starts like this: Vincent Wambua Musia, capital letters, bold, underlined with a colon, on the 12th day of August 2012 at Mlango Kubwa, Starehe District, Nairobi County, intentionally and unlawfully committed an act which caused his penis to penetrate the vagina of Faith Ngami Thomas, a girl child of 13 years. So you can see here that the details and relevant facts showing the crime and the act is very specific to penetration, not anything else. This is for clarity of cause and to bring the cause of complaint, okay? Clear and precise without any ambiguity. For example, if they had written he touched her, or he caused their bodies to be together, or some other ambiguous terms or word choices like that, then obviously it could fail. The charge could fail by maybe confusing the offenses, or failing to disclose clearly and with precision the cause of complaint, which offense is defilement. Okay, so there's also an alternative charge. So in brackets, there's an alternative charge, C overleaf. So we'll see the alternative charge here that is being written after the charge. Down there, it says indecent act with a child, contrary to section 11, subsection 1 of the Sexual Offences Act number 3 of 2006. So the alternative charge is also followed by its particulars. Vincent Wambua Mosia on the 12th day of August 2012 at Mlango Kubwa in Starehe district within Nairobi County intentionally and unlawfully committed an indecent act with Faith Ngami Thomas, a girl child aged 13 years, by touching her private parts, namely vagina. vajayjay. So, yes, you can see the particulars are very specific details and specific to qualify the offense or disclose the cause of complaint. Which offenses are first we saw it is defilement, and this needed particulars which disclose the element of penetration. So there is the element of penetration as well as the child, the child sex being female, a girl child of this much years, 13 years. And these years are important because of sentencing. Every age attracts a different sentence. Now, Vincent, and then we see the alternative charge. We have specific particulars that will disclose this particular offense, the element, which is touching the private part. So this is touching. The other one had a very specific detail of penetration. So that is just to see that the particulars must contain only relevant facts of day, of month and year, of place, and of the particulars necessary to disclose the cause of complaint clearly without any ambiguity or mixing up, okay, of the offenses. Now we follow that with if accused arrested. Yes, the answer is yes, he was arrested. Date of arrest, the 13th of August. All right. So he was arrested the next day, the following day, after he had committed the offense. Now, without or with warrant, without warrant, date apprehension report to court. He was apprehended. Okay, date of apprehension report was 14th August 22. I don't understand whether this is the date of arraignment or the date of, no, this can't be the date of arraignment. This must be the police reporting the arrest to court, because he made this arrest without warrant, so the magistrate would not know unless he was informed. So the date of report was on 14th, the next day, and bond or bail, whether he was given bond or bail, no, he is in custody. All right. Then we move on to a section that asked whether he is remanded or adjourned to something, and it doesn't have anything. So complainant and address, we have the complainant address. The complainant is the victim, Faith Ngami Thomas. Witnesses is the next box. So witnesses, number 1 is the complainant, who is Faith Ngami Thomas. Number 2, Dr. Kamau. Of course, when you are raped, the first thing that you are supposed to do as a post-care rape is to go to a hospital and get your, do they call them P3? I don't think it's P3, PCR or something. There's a form you get where the doctor examines the victim and records what they have observed, all right, downstairs there. So the witness number 3 is Anne, and the number 4, others to be stated. Sentence, court and date, it is empty. So the court is Makadara on 14th August. So this charge sheet is signed by the officer in charge of Pangani Police Station. It also bears the Chief Magistrate's Magistrates Court seal, as well as some other random sign on the charge, okay, on the on the, I don't know, on right there on the charge. And also there's the OC prosecution Makadara got OC Pro. I can't read it, it's faint. So so yeah, then that is followed. It's followed by the alternative charge and some other box which states which has these columns of date and time and the actions: police action, accused in form of charge, searched and placed in cell by, prisoner property book number, bail book number, fingerprints taken by, fingerprints to bureau, fingerprints from bureau, completed certificate of previous convictions to bureau, first information and progress report to Commissioner of Police, final report Commissioner of Police, charge register completed and case closed. All right, so that is that other example. Okay. All right, so there's another sample here which is very interesting because it is a sample of a complainant who is not a Kenyan national, but he is a Congolese national. So this, it looks different from the normal charge sheet. It starts with this M44. I don't know what code that is. Immigration case number 123 of 2019. Court case number 3, 2019. Date to court 2nd of January 2019. Republic of Kenya charge sheet in the Chief Magistrates Court at Nairobi. Name of complainant. So then we have Republic of Kenya through the Director of Immigration Services. The name of the name is, there's a small little tiny table of only 5 columns and 2 rows. So the first column is name, and the name is Exos Lawrence McDonald Ati Monza. The sex is male, nationality Congolese, age is adult. All right, address not known, offense complained of as per attached sheet. So we'll see below particulars of offense, we'll see them below. Signature of magistrate, signature of complainant here. All right, now count 1. Being unlawfully present in Kenya contrary to section 53 subsection subsection 1J as read with section 53 subsection 2 of the Kenya Citizenship and Immigration Act of 2011 laws of Kenya. So we have the count 1 being unlawfully present in Kenya. Count the particulars you write the name of the person, then you underline. On the 29th day of December 2018 at Jomo Kenyatta International Airport within Nairobi County, being a Congolese national, you were found to be unlawfully present in Kenya in that you did not have a valid passport, a valid pass or permit allowing you to be present in Kenya. Count 2, failure to comply with term imposed by a pass, contrary to section 53(1)(l), as read with section 53(2) of the Kenya Citizenship and Immigration Act 2011 laws of Kenya. Particulars of the offense: on the 29th day of December 2018 at Jomo Kenyatta International Airport within Nairobi County, being a Congolese national, you are found to have failed to comply with terms imposed by a Kenya transit visa while attempting to depart Kenya to Toronto, Canada, using KLM Royal Dutch Airlines flight number KLM 556. So the second count is he was found to have violated his visa, okay, while attempting to leave Kenya to Canada. Now count 3, knowingly using a forged residence permit contrary to section 54(1)(c) as read with section 54(2) of the Kenya Citizenship and Immigration Act 2011. The particulars are: on the 29th day of December 2018 at Jomo Kenyatta International Airport within Nairobi County, being a Congolese national, you are found using a forged Canadian residence permit number 87785477, purporting to have been lawfully issued to him by the government of Canada while attempting to depart Kenya to Toronto, using KLM Royal Dutch Airlines flight number 556. So count number 4, knowingly using a forged residence permit contrary to section 54(1)(c) as read with section 54(2) of the Kenya Citizenship and Immigration Act 2011 laws of Kenya. Particulars being: on the 29th day of December 2018 at Jomo Kenyatta International Airport within Nairobi County, being a Congolese national, you are found using a forged Canadian residence permit number 88785477, purporting to have been lawfully issued to him by the government of Canada while attempting to depart. I think this is a repetition. Yeah, this is duplicity. I don't know why they would do this. They would do this twice, maybe to teach us or something. So that is a okay, it's a duplicity of charges. I don't know which rule this is. Let me just see. Let me just see if there's any. I'm sure there must be here. Duplicity. It is a requirement of law and practice that a charge should not suffer from duplicity. That is to say, no one count of the indictment should charge the prisoner with having committed 2 or more separate offenses. So similarly, we have a case, Jilani versus Republic. The principle of the law governing charge sheet is that an accused should be charged with an offense known in law. The offense should be disclosed and stated in a clear manner so that the accused may be able to plead to specific charge that he can understand. It will also enable the accused to prepare his defense. Now, this for our purposes will suffice as a definition for the term duplicity. The same definition is also attributable to the English case of Republic versus Morley, What is contemplated by the definition can be illustrated in also in the English case of Republic versus David, where the charge read on diverse dates between January 1909 and 4 October 1910. And in another count, on diverse dates between 4th of October 1910 and the end of February 1913. Such a charge is defective in that there is a considerably long stretch of time between the count. These are two offenses which should receive separate treatment, but where the offenses charged consist of one single act, they may be made the subject of a single count. For instance, when the prisoner was charged in one count with uttering a number of forged receipts, and it was proved that all the forged receipts were uttered at one and the same time in one bundle, the count was held good and not bad for duplicity. This was the case of the King versus Thomas. Likewise, a man may be indicted for battery of two or more persons in the same count where the battery is one transaction, or for a libel upon two or more persons when the publication is one single act without rendering the count bad for duplicity. This was stated in the case of R. Republic versus Benfield. What the above judicial authorities indicate is that a count charging a person with one endeavor to procure the commission of two offenses is not bad for duplicity because the endeavor is the offense charged. That it's alright. So I think duplicity occurs even where the charges are framed in the alternative. Okay, so I don't know. Alright, so we see here that we have another example of duplicity of charges in a case of Saina. It's an appeal case of Saina versus Republic, where the appellant was charged on a single count during trial with the offense of housebreaking, theft, and handling stolen property. So it's just one single count saying on this particular day of this year, in this place, so and so was found breaking into breaking into a house, stealing and handling the stolen property. And the magistrate found he had committed all the offenses and sentenced him. But on appeal, Sir James Weeks and some other judge held that each offense must be settled in a different count. So each offense must be settled in a different count, and that failure to do so is an incurable illegality. The court followed the earlier decision of Cherebe, Gokuri versus Republic. The reasoning behind this was that had the charge sheet been given proper consideration, it would have been seen that the first count charged not the permitted one offense, what the heck? But 3, shop breaking, contrary to section this of the penal code, theft under this and handling against this. So this created confusion and a number of errors were made. The court restated section 135 of the Criminal Procedure Code that where more than one offense is charged in a charge or information, a description of each offense shall be set out in a separate paragraph of that charge. So that is one of the rules of charges of drafting a charge where somebody is accused of several offenses. Those offenses must be set in separate paragraphs, one after following the other, and they must be each quoting the relevant section of the law which has made that offense an offense. Now, in every paragraph will be referred to as a count, okay? So this under this thing, duplicity, put the counts separately where there are several offenses. So that's the rule, but I didn't see what happens when you repeat the same offense. Here it looks like there are 2 counts of similar offense, and I don't know what happens when this happens. Let me just see, maybe they have something here. Okay, so let me just move on. So we see that is one of the examples there of these counts and the particulars. Yeah, and they're all separate with their own particulars. All right, so this is, I don't think I should go like see everything here, because most of these things we have all right, that we have seen, and we see that where there are several offenses, you will state them as count 2, count 3, after you have drafted your box or the columns with the columns with the name, the particulars, I don't know what they call this box, but after it's called a sheet, maybe, I don't know what we can call a table. Yeah, after you've drafted the table and included the charge, if you still have other counts, you state them down below with their particulars. Yeah, and that is charge sheets for you, and I'll see you next time. Bye.